this is something I've been digging into, this as well as some other incidents in DeSoto Parish, but particularly this case from Mr. Brown. When did it all come to your attention?
It was from your reporting that it came to my attention, to be clear. And I don't know if you just saw the AP story that came out about it. They cited to your reporting because I directed them to your reporting as well. It came to me through interesting channels, which was, hey, read this article. You need to look at what happened here. And that's sort of how it came to our attention. And then how we then in turn did some sleuthing to get a hold of Mr. Brown. Of course, as we discuss in our challenge, that itself proved challenging for us. So we were in fact speaking with a family member about what had happened. And so while we were, preparing all of this stuff, we were not actually able to have a concrete conversation about filing suit with Mr. Brown until he finally moved facilities. And then all of a sudden, we had a very different reaction to the prospects of bringing suit. And the family member, of course, was very invested in having us work on this case.
Let me ask, when you, as part of the legal team and the rest of your co-counsel, looked at this video for the first time, what was your reaction?
This is horrific. I mean, how can we treat folks in detention facilities like this? And at no point in time do I think there is any reason to treat someone in this way. And so I think that the after effects of what happened to him, from my perspective, it's going to be very hard pressed to justify how the beating that occurred was lawful. But as you know, because of what happened, our first battle here is going to be with Louisiana's 1-year statute of limitations. I mean, that's the first volley and battle is going to be that, and why it is so prohibitive to a human being. And that's where we're going to start. And then ideally we'll be able to actually get to those facts. But that initial fight, that's going to be a big one, because the law that's been developed on that is not great. I stand by the fact that the law that's been developed on that has not been briefed as well as I would have liked to see the issue briefed. But of course, there are no guarantees that even when you present all of these arguments, that you're going to get a favorable ruling. But I do see this being an issue that we would take up to the very end, right? So even if we see a loss at the lower court, we are going to want to take that up to the circuit. And if we see a loss at the circuit, we're going to heavily consider seeking cert. I imagine it will take the Supreme Court some time before cert gets granted on this issue. But Mr. Brown's is not the first case. I mean, it is the first case where we will be challenging the SOL, but it is not the last case, because unfortunately, the trauma that police violence inflicts on human beings makes it extraordinarily difficult to get them in a position where they're actually thinking about filing a civil suit, especially when they're within the clutches of the criminal legal system.
And when you look at that video from the body camera, and now you've had the opportunity to interview and speak with Mr. Brown, what is it there that leads you to believe and file a claim for excessive use of force?
So we outline that in our complaint, and that is largely based on the facts as we understand them right now. Mr. Brown did not provoke or conduct himself in any way that would have elicited a force reaction, let alone an excessive force reaction. Now, there will be, in all likelihood, discovery. There, I imagine, is other potential video evidence, other angles to potentially look at. But whenever you're looking at excessive force, you're looking at a continuum, right? It doesn't just begin and end, oh, the individual, told the officer, step back, and then the individual's arm was grabbed by the officer. That grabbing of the arm could potentially be lawful. But when you continue to beat someone and they don't do anything, now you've got that arm and that arm's not moving, then we move into excessive force. The same thing happened. Let's say they moved the arm and you grabbed it and then they moved it again. There might be some force under the law, whether or not I agree with it, under the law that provides for a commensurate use of force in response. But what we're talking about here when we're discussing excessive force is that the force used is not commensurate. And we have Fifth Circuit case law that recently came out at the end of last year that was very clear that there is a constitutional requirement on officers to use de-escalating force when the individual before them is no longer responding in a forceful way. And there is no right to use force when that individual has been, quote, subdued. So somebody who is not doing anything can't be beaten. Even if they say something you don't like, you cannot beat them. So there are more details to uncover about exactly what happened, but we stand readily confident that that result, what we see happen to Mr. Brown, that result is a result of excessive force.
I read the lawsuit and we get new details now from Mr. Brown's account that he was allegedly struck several times in his face and his torso while stripped naked.
That is our understanding of the facts as they stand right now. And we'll go, in an ideal world, at a certain point, we'll get to discovery and we'll be able to actually get a deeper understanding of exactly what happened. But the facts as we understand them to be right now are those that we alleged in the complaint.
And can you tell me what some of those facts are briefly as to what happened to Mr. Brown while he was in the custody of at least 2 DeSoto Parish sheriff deputies and maybe a state trooper?
So it's our understanding that Mr. Brown is stopped by a state trooper, that he's then taken to the DeSoto Parish Correctional Facility. At a certain point in time, he is taken to a laundry room where he is ostensibly supposed to change into a jumpsuit. He is told effectively to turn around, to bend over, to cough. And our understanding is that he then turns to face those officers and then he gets beaten without provocation and for no reason. That is our understanding, and that it's not 1 punch or 2, it amounts to a multiple force beating that even after Mr. Brown convulses over, he's then given 1 final punch. And so when we talk about excessive force, we have to look at every single use of force, every single punch, if there were a kick, every potential kick. And then we need to look at what happened after the individual was down. And so even if there is a ruling, and we don't know what will happen, that an amount of force could have potentially been justified based on a reaction that happened in that room, as alleged, when you're talking about somebody that is unable to move and is doubled down and bent over, that final use of force is unjustified under the law.
We know he was injured because we can see it from the videotape and from accounts that I got at the time from sources and witnesses, but I imagine you all will be able, with the cooperation of Mr. Brown, to get his medical records to know, while he may have not had life-threatening injuries, he was seriously injured in whatever happened in that jailhouse.
That is where we're headed in this lawsuit. Unfortunately, because of Louisiana's 1-year statute of limitations, there is a possibility that all of the facts that need to be unveiled and revealed in this particular case will not come to light unless we can actually get over that hurdle. But the public has a right to know. The public needs to know what law enforcement is doing, and that we have an arbitrary statute of limitations, I would argue for Louisiana, amounts to something that's far worse than qualified immunity, because we're effectively saying that this person is not even allowed to come in and complain and say that their constitutional rights were violated. We have a constitution, We have the 14th Amendment. We have the 4th Amendment. Individuals have the right not to be abused in the way that Mr. Brown was abused. But because of arcane rules, and I would say they're procedural rules under the law, we are sitting in a state that says that you only have 1 year to bring that claim. In Maine, you have 6 years, but in Louisiana, you have 1. We are one of 3 states that place this burden on civil rights litigants. And that is something that we need to reconcile when we're thinking about a case like this. You know how hard it was to get a hold of Mr. Brown. You understand what challenges were faced in just getting a hold of this man to understand what happened. It's not shocking that it took 2 years to get to a point where he, having faced the trauma that he did, felt that he was in a position to do something about it. And that's also what we try to focus on in the complaint. When people say, well, you know, a year's a long time, I could have brought a case. We have to understand trauma. And we have to understand that this state legislature, when you're talking about a state tort, said if you've experienced a crime of violence, you get 2 years to bring your suit. But the way that a 1989 Supreme Court case operates means that this state has interpreted that precedent, and I disagree with that interpretation, to mean that when you're seeking to invoke your constitutional rights, the period of time you have to do that is shorter, even though the complexities of a federal civil rights case is more complicated than a torts case.
And let me ask you that then, while the state claims may have told due to the statute of limitations, will this 42 USC 1983 civil rights action be able to still go forward even if the court rules against the Louisiana statute of limitations?
So it's actually the inverse. The way the Louisiana statute of limitations work, I mean, I can give you this very brief primer, right? So there's effectively the Supreme Court case that looks specifically at how long do civil rights litigants in the country have to bring a Section 1983 claim, because the federal statute doesn't actually provide a statute of limitations. So in 1989, the Supreme Court said, well, we understand that states have particularized statutes of limitations, and we understand that they have residual, effectively catch-all statutes of limitations. In the case before the Supreme Court, this is Owens v. O'Cure, they said, okay, the residual statute of limitations here is longer than the more particularized statute of limitations, so we're going to say the residual statute of limitations applies. So in that particular case, that was a case coming out of the Second Circuit. That meant that the individual got the residual SOL, which was longer, which gave them a longer period of time. But in a state like Louisiana, what that meant is we have to go to the residual statute of limitations and see how long that is, because that is 1 year, even though in state court and under the state court claims you have 2 years, you only have 1 year when you're talking about bringing your federal constitutional claim. So in all likelihood, it would be the inverse.
Well, I would like to have said in my story that you feel confident the officers allegedly responsible will ultimately be held accountable. We have serious worries that could not and possibly may not happen in this case.
It may not happen in this case when we're talking about the violation of federal constitutional rights. We have a battery claim, but there is a difference between saying somebody was battered under tort law and saying that these police officers violated the United States Constitution, and there are ramifications that need to follow from that. This is not an errant battery. This is unconstitutional conduct that we as citizens of the United States will not stand for.
Have you gotten any cooperation from LSP or DeSoto Parish Sheriffs in the initial part of your investigation in filing these suits?
So right now we have just filed our suit, and so we have not engaged at this juncture with asking them for documents and evidence, et cetera, which I imagine they would say, you're not entitled to in the posture of this case because you've brought a case that exceeds the statute of limitations. Of course, we would be very open and happy to get that additional information, though we do have grave concerns that LSP is the governing body doing these investigations. Unfortunately, what came to light, as everyone saw with Ronald Green's killing, is that LSP might not be forthright with their documentation about the events that transpired. And we are concerned that an LSP officer allegedly initiated this stop and was involved in the handover. And we don't know what was stated during that handover. We don't know if there is implicit or direct involvement in the violence that ensued. And that is something that is essential for Louisianans to understand, because we have to get comfortable with what exactly the Louisiana State Police are doing when they conduct these investigations. And unfortunately, we don't have a lot of evidence that they are being conducted in the way that we want to see them conducted.
And if we don't, we could continue to see incidents like Mr. Brown play out outside of the public's view.
Exactly. And so you've got a statute of limitations, and then you have a governing body that's conducting an investigation that I think the state has lost a lot of faith in the accuracy of those investigations and the outcomes of what the Louisiana State Police say. Because if the Louisiana State Police, the body that is supposed to be the most esteemed in this state, has fallen in the sense that we now know that they're withholding evidence, that they're not being forthright with the public about what happens to individuals their officers encounter, then how can we rest assured that when they investigate other officers for similar conduct, that they're actually going to find wrongdoing? If they don't believe their own conduct is wrong, how are they going to enforce the misconduct of others being wrong?